Good morning. The first case to come before the court today is State of Ohio v. Eric Kilgore. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. As you may know, the arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or minors or victims during your argument. The judges have read your briefs and we're ready to proceed when you are. And would you like to reserve time for rebuttal?
Yes, Your Honor, I would like to reserve 5 minutes of my time.
Okay, and also please introduce yourselves.
Yes. Good morning, Your Honor. It's Giovanna Bremke on behalf of Mr. Kilgore. Mr. Kilgore and his co-defendant were charged with 4 counts. He was ultimately convicted of 2 of those, and also the specifications that go along with those. All 4 had 1- and 3-year firearm specifications. The allegations are interesting and the facts I think vary depending on which side or which person that you hear them. But essentially, there was an instance where there was a Mr. Kilgore's co-defendant who was in a relationship with a gentleman at a time and had loaned him $600 through a Zelle payment. There was an agreement that he repay that, and he had not repaid that. So again, depending on which testimony there is, but at one point he comes over to the house and a fight ensues between him and Mr. Kilgore and the co-defendant. My client was found not guilty on counts 2 and 4 and the firearm specifications associated with that. The co-defendant was only convicted on the first count and none of the specifications. This was a bench trial that was consolidated with the co-defendant and 1 attorney representing both co-defendants. My client was sentenced to community control, but 3 years on mandatory on the specifications. I've raised 4 assignments of error. The first being that the specifications, there lacks sufficient evidence for the specifications, the firearm specifications. And I wanted to point to the record, various parts of the record where there is testimony that there was no gun. So there was an eyewitness to the incident, that's transcript page 206, he says no gun. The co-defendant testified, transcript 263, she says no, there was no gun. And my client testified, transcript page 283, that there was no gun.
Counsel?
Yes.
Counsel, did the victim testify there was a gun?
Yes, so that is the only person who places a gun. There's no specificity as to the gun. And also there's a deputy that testifies that there was injuries that could have been consistent with a firearm. But when he's asked on cross-examination, and this is page 153, 154, there's a big dialogue, and I put that in my brief, about whether there's a firearm. And he's asked, what kind of firearm is this injury consistent with? Because firearm is very general, right? Is it a pistol? Is it a long barrel, short barrel, whatever it may be? And the deputy's not, he admits, I can't say what firearm this would be consistent with, or that it could have been consistent with something else. So the only one, again, there's a completely neutral eyewitness who says, I never saw a gun. So the only person who places a gun there, and this is obviously significant for purposes of the firearm specification, is that one individual. And what I argue in my brief and what I'll contend to today is that the testimony of that individual is not reliable. There's a lot of inconsistencies, a lot of things that he can't remember, and even just as to the firearm itself, there's not a lot of specificity of what kind, things of that nature. So I would ask, another thing I forgot to add, but I did argue in my brief that there's absolutely nothing on operability of the firearm at all. So we would ask that you reverse on that specification. Second assignment of error is that the verdicts are inconsistent, and a lot of the case law that's presented in this area in terms of a inconsistent bench trial, because again, that's significant here that there was a bench trial. A lot of the case law deals with inconsistencies within the same verdict, within the same defendant. This is a unique situation where, again, there's co-defendants, identical indictments, identical set of facts, and yet we have an inconsistent verdict. So there's no finding on the firearm specifications, and also a not guilty on the third count, and that's where they vary.
In this case, it's, at least from what was alleged, the other defendant did not ever have or possess a gun, as I understand. Was there complicity argued to the judge in this case, as the fact that other defendant should be complicit on the acts of the co-defendant?
I believe that was pretty much the state's entire case was the complicity argument as to the co-defendant. So that's where the inconsistency is not, it doesn't necessarily jive. And again, the
Counsel, you cite Mayberry as a basis out of the Second Circuit Court of Appeals. And are you asking us to extend Mayberry here?
Well, again, I don't think Mayberry is absolute, the facts of Mayberry are not the facts here, obviously. But the Mayberry stands for, hey, a trial judge it's different than a jury, right? We have to recognize that. And a judge is expected to know the law more than a jury. And I think that that's why this being a bench trial is something that is important, because the judge is expected to know the law and expected, under a complicity theory, how does this verdict make sense? Sometimes we aren't able to make sense of what a jury would think. And that's the nature of the system. That's the nature of our rights of having the right to a jury trial. But when you opt for a bench trial, you are opting to take away some rights, but in exchange, you're opting to have a trier of fact that is expected to know the law. And Mayberry talks about, whether a judge should exercise leniency in some areas. And in this case, I think that was, maybe part of the ruling as well. That there's exercise, if it doesn't make sense legally, then the only assertion could be that there's exercise of leniency. And what Mayberry stands for is that's not the time to exercise leniency in the verdict. The judge, knowing the law, can exercise leniency in the sentence. There's also the third assignment of error about the jury trial waiver. And in that assignment of error, this is sort of a first impression that I could tell from this court, but as the state points out, there are cases from the 8th District about this particular argument. And in this case, there was a jury trial waiver. We don't argue that it was in writing, that it was executed, that it was in open court, but that it was filed after the beginning of the jury trial, or the bench trial, I'm sorry. And it's our assertion that if there's strict compliance, it needs to be filed prior to the beginning of the bench trial, I'm sorry. And the last assignment of error deals with ineffective assistance of counsel in regards to conflict situation. So again, this counsel had represented both co-defendants. And I argue plain error because it's not objected to, and in fact, as the state points out, there was a dialogue about the potential of a conflict there. But I think that there is enough to overcome plain error, and the nature of the argument needs to take into consideration the fact that when there was this dialogue, there is an inherent conflict with the counsel itself, that there is a benefit to the counsel to represent both. And so in that dialogue itself, there was maybe some ineffective assistance because the counsel has an inherent benefit that would be conflicting with my client's interest. So, I think that the court needs to weigh that in consideration of that dialogue
What
that
is
happened.
counsel, what was counsel's inherent benefit?
Well, I'm representing two individuals, so, I mean, presumably there's, you know, a benefit to getting, I mean, I'll be honest, to getting money for two individuals and having to streamline a trial.
So counsel, what you're suggesting though, wouldn't that be true in any case where there's counsel representing co-defendants?
Well, and this court has consistently held that there's, you know, that representing co-defendants should be scrutinized.
Sure.
But what I'm saying is particular, and what I'm talking about is that dialogue. So I think that dialogue between the court and my client, whether he's being represented in that regard, I know I'm coming up on my time.
You are into your rebuttal time, so I.
Yes, but that conversation, I think that that's something to consider within that conversation. But, and again, I think that that's where the judge comes into play as the guardian of the rights here, the superior guardian, I would say, of my client's rights, and whether those were, whether those were infringed upon by having counsel for both. The state alleges that, you know, how would the defense have been different? And I think that, you know, when you see the way that the fact pattern progresses, depending on who testified, it's obvious that there was a conflict there. So I would reserve the rest of my time. Thank you.
Thank you. You'll have a little over 4 minutes for rebuttal.
Thank you.
Good morning, Your Honors. May it please the court, Lindsay Poprocki on behalf of the state. I'll first address the sufficiency argument that's been raised as to the firearm specifications. And it's been well established by the Ohio Supreme Court that a fire enhancement specification can be proven beyond a reasonable doubt by circumstantial evidence and with reference to the totality of the circumstances. Therefore, a trial court may refer to all relevant facts and circumstances surrounding the crime and can consider victim testimony. And any implicit threat that was made by the defendant that was in control of the firearm. Kilgore essentially maintains that the victim's testimony here was not enough and that the only evidence presented to sustain a conviction were his words. This court has stated that witness testimony that the defendant was holding a gun while committing a robbery and created an implicit threat to shoot is sufficient proof of both operability and can sustain a firearm specification. And the victim in this case testified that Kilgore's co-defendant essentially lured him to her apartment to engage in a sexual act so that she and Kilgore could rob him. The victim testified that once he was in the bedroom with the co-defendant, he observed Kilgore holding a gun at the door, and then he was pistol whipped in the temple on his face, near the side of his face, and then held on the ground at gunpoint while the co-defendant took his cell phone, demanded his passwords, and then transferred money from his bank account to her own. Sheriff's deputies later made contact with Kilgore, observed his injuries, and took photos of those injuries, which were presented at the trial. The deputy testified that Kilgore's injuries appeared as a knot on his face, on his eye bone, which ran along to the temple. Kilgore's attacks here on the victim's credibility and the believability of his statements are more appropriate for a manifest weight argument and do not go to the sufficiency of the evidence. When viewing the evidence in the light most favorable to the state, which this court is required to do, there was sufficient evidence to maintain the convictions on Kilgore's firearm specifications. As to the second assignment of error, which goes to the inconsistent verdicts allegedly rendered by the trial court in a bench trial, Kilgore in his brief did ask this court to extend Mayberry.
Do you find the verdicts inconsistent? You said allegedly inconsistent. Your brief was not clear to me. Do you concede they're inconsistent verdicts, or you disagree with that?
As you indicated, as you previously indicated, there was no testimony that the co-defendant in this case possessed a firearm. There was testimony that Kilgore was the only one that brandished or had a firearm on his person. And that's not necessarily inconsistent to find her not guilty of the firearm specifications.
Were there arguments made for complicity before the trial court that she should have been responsible for Kilgore's acts, that they were acting together?
I believe there was complicity. So, in any event, this Kilgore's invitation to adopt Mayberry and extend it to bench trial verdicts, we cited case law in our brief, both from the United States Supreme Court and other districts, who flatly rejected the notion to extend Mayberry to bench trial verdicts. And we would ask this court to do the same. With respect to the third assignment of error, on the validity of the jury waiver, that assignment of error goes to the timing of the jury waiver, because Kilgore has conceded that the jury waiver was in writing, that he signed it, and that it was made in open court. The state has cited to several cases in its brief from the 8th District, who has consistently rejected the argument made by Kilgore that the jury waiver must be clerked and filed before the commencement of the jury trial, the bench trial. There is no rule in the statute as to when the filing must occur. This 8th District has made that clear, that in plus and in the statute, there's no rule that says that the jury waiver must be filed before the bench trial proceeds. It only says that the filing must occur and that the jury waiver must be made part of the record. And here, the jury waiver was filed, albeit after the bench trial commenced, but it was and is contained in the record. And we would note that Kilgore cited to a case from this district, the State v. Lugo, but that case is distinguishable in a couple different respects. In that case, the state conceded error because the waiver was never even executed, never made a part of the record, and there was no colloquy in open court. So that case is clearly distinguishable. As to the ineffective assistance of counsel claim, Kilgore elected to voluntarily retain and be represented by the same counsel as his co-defendant. Despite his choices, he now claims ineffective assistance of counsel due to joint representation. And he now claims that he objected to this representation, but the record does not support this claim. In fact, not only did he fail to object to the representation, the joint representation, he knowingly and voluntarily entered into this joint representation after an inquiry by the trial court at a pretrial hearing. His co-defendant did the same. The trial court explicitly made a finding that joint representation was waived. And this is not to be reviewed on a plain error standard, but as to whether there is an actual conflict in the representation. The mere possibility that a conflict could exist does not establish that one did exist. Kilgore has failed to demonstrate that an actual conflict did exist. The state would ask that Kilgore's convictions be affirmed. And there are no further questions.
Would you like to respond, counsel, if you would, to the argument, the general argument that was raised by the defendant, that counsel's theory that the co-defendant was in a relationship with the victim and the co-defendant, and a fist fight broke out, might have hurt him,
would have been a conflict. I'm sorry, did you say that?
Yeah, sure, it was not well stated, so it's my fault, not yours. What, I believe here, that the defendant argued generally that counsel's theory that he was in a relationship, that they were both in a relationship with his co-defendant, and a fist fight broke out, put him in a bad light, and represented a conflict, because of that theory of the case. Was that a conflict?
I don't believe that was a conflict. They both indicated that a fist fight broke out so that there could have been no pistol whipping. And then that because there was only a fist fight, there was no gun, which goes to the argument that there is no sufficient evidence of a firearm specification. That would be my response.
Okay, thank you.
Thank you.
Okay, good morning again. I wanted to address a few things that were brought up, specifically as to the specification. And there is, this assertion that GS in the case, that he testified as to this firearm and things of that nature. But again, specific to that testimony, it's not elaborate. And to counter that testimony, you have, again, the co-defendant, Mr. Kilgore, an independent witness
But
all
isn't
saying.
that, as the state said, isn't that more of a weight argument that you're making? Your assignment is sufficiency in that way. If you want to start looking at what everyone else said, isn't that weight as opposed to sufficiency?
I would still argue it's the sufficiency, that there wasn't sufficient evidence on those specifications. And again, the deputy in this case is saying, but for, GS saying that he was, pistol whipped, what other evidence would there be? And he's saying, no, it's not, he said, I wouldn't even look at those injuries and think, yes, that's a pistol, but for the assertion of him. Also, he testified that he had full access to the apartment, that he searched the apartment, that he took photos of the apartment. There's never any firearm recovered at all.
Counsel, didn't the victim testify, I seen somebody with a gun, that's when I first got pistol whipped, I went down, I was held at gunpoint.
Yeah, and he's saying he's held at gunpoint out in open where this other witness is, and this other witness is saying, no, there's no.
I understand, but again, that goes to the point of the credibility of the witnesses. And then, wasn't there also, didn't he also indicate that when he was face down, there was a gun pressed against his head?
Correct, and again, my assertion is that there wasn't sufficient evidence, there was, other, this witness who would have saw that entire thing, that's not something that you would forget, and it was, an independent witness.
And then there was, didn't he testify that he was hit in the face with the gun?
Yes, but what I'm saying is there really was no specificity of that gun, and these incidents are happening where this other witness could have seen.
I understand, thank you.
And I will say to you, I think it's, it's in the record, the sentence in this case was stayed. Even though Mr. Kilgore was convicted of a firearm specification, he's in the courtroom today. And I think that, and that's mandatory time. I think that that's significant in that this was a bench trial and the trier of fact felt comfortable enough to allow Mr. Kilgore to remain out, and perhaps that goes to the weight of the specification as well. So again, we would ask that you reverse the count, or the convictions and the specifications, and remand to the trial court. Thank you.
Thank you very much, both of you, for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.